Why would anyone want to be in a Chapter 13 bankruptcy that feels like it lasts forever? I know that sounds completely crazy, right? But for some people, especially those with private student loans, that never-ending Chapter 13 feeling might actually be the only thing standing between them and financial chaos. Most people have heard there are some great government programs to help with federal student loans, income-driven repayment, forgiveness options, things like that. But here's the catch. Those programs are for government student loans. If your loans are private, it's a whole different ballgame. If you fall behind on your private student loans and the lender gets a judgment against you, they have some very powerful tools, especially here in Georgia. They can garnish your paycheck up to 15% of your take-home pay, clean out your checking account, put a lien on your home, and they don't have to care what it costs you to cover basics like rent, food, gas, or childcare. They just want to get paid. That's where Chapter 13 can change the picture. When you file a Chapter 13 bankruptcy, the garnishments have to stop. The creditor can't just raid your bank account. They can't move forward with collection while you're under the court's protection. Instead of a random, painful garnishment, we put you into a structured payment plan that has to be reasonable. What does reasonable mean? It means the court looks at your budget. You've got to be able to pay your basic living expenses first, housing, utilities, food, transportation, before money goes to the Chapter 13 payment. In many cases, that Chapter 13 payment can be much lower than a 15% wage garnishment. Every situation is different, and you need to talk to a local bankruptcy attorney to see what it would look like for you. Now, here's the part people find interesting. By law, a Chapter 13 plan can only last up to 60 months. That's 5 years, not forever. And for most debts, when you finish that 5-year plan, you get a discharge, a legal wipeout of many types of debt. But with private student loans, getting them discharged in bankruptcy is extremely difficult under the current law. So what happens when your 5-year Chapter 13 ends and that private student loan is still there waiting for you? In some situations, a person may choose to file another Chapter 13 case right after their other one closes out. Will you get a second discharge of your debts in that new case? No. So why in the world would anyone do that? Because that second Chapter 13 can give you another 5 years of protection from that private student loan collector. More time where they can't garnish your wages, can't empty your bank account, and can't come after you the same way. For some people, that ongoing protection is the difference between living with constant financial fear and having some breathing room to live their lives. I personally believe that one day soon, someone in Congress is going to run on a platform of making student loans dischargeable in bankruptcy just like any other debt. And when politicians finally realize how many Americans are struggling with this, I think things could change quickly. But until that day comes, people with private student loans still have options, including using Chapter 13 and, if necessary, filing more than one case. If you live in the northern half of Georgia and you're being threatened with a wage garnishment, bank levy, or liens because of private student loans, don't wait for things to get worse. I'm bankruptcy attorney Jeffrey B. Kelly, and my team and I help people in the Northern District of Georgia explore their options under Chapter 13. We offer free consultations and we'll walk you through what a Chapter 13 payment might look like in your specific situation. There's no pressure and no judgment, just honest information so you can make the best decision for you and your family.